Well, a very good evening and welcome to a special broadcast right here on CNBC TV 18. We're calling it BEZOS versus BIYANI. That's the battle that's currently underway before the Delhi High Court. What's at stake essentially are big numbers. Let me get you familiar with those numbers. It's essentially a case of Amazon's investment of 1,430 crore rupees versus the BIYANI deal, the future retail deal worth 24,700 crore rupee deal. That's what's at stake before the Delhi High Court. And speaking of the High Court, as we're all aware, Future Retail, I'll refer to it as FRL. FRL has filed a suit before the Delhi High Court. Let's take a look at the concerns and the arguments that they've raised so far before the Delhi High Court. The first is the number one argument that FRL raises is that Amazon is simply absent from the shareholders agreement, that Amazon has no rights, no control over FRL, and that is what they've sought to establish, that Amazon's investment is limited to future coupons or FCPL. That's argument number one. The second argument is, and this is where Future Retail argues, that there's been a bit of a flip-flop by Amazon. FRL says that before the CCI, Amazon said that their investments are limited just to FCPL. They had nothing to do, no control over FRL. Before SEBI, in the latest letter, Amazon says that this investment that they made was a single integrated transaction involving both FCPL as well as FRL. That's argument number two. Number three argument that they've raised is that this arbitration that we're speaking of, the seat of arbitration is India, governing law is India, and what's important to recognize is that under Indian law, the emergency arbitrator is simply not recognized. There is no recognition of the concept of emergency arbitrator, which essentially means is that the interim order passed by the emergency arbitrator is only persuasive and is not binding. That's the second point that they've made. That's argument number three that has been made. Argument number four that has been submitted is that while Future Group did participate as a part of these arbitral proceedings, let's keep in mind that they submitted to the emergency proceedings under protest and without prejudice to their arguments that they have with respect to SIAC's jurisdiction, which is yet to be decided by the arbitral tribunal. So that's one key argument that they've put forth, that they've submitted to the emergency arbitrator proceedings, but they've done so without prejudice and under protest. That's argument number four, an important argument that they've put across. Argument number five is, and this is one argument that keeps surfacing, that if Amazon is so firm and is so confident of its position, why have they not moved the Delhi High Court or the Bombay High Court seeking enforcement of these interim orders? That's argument number five. Number six is that the rights that are claimed by Amazon, that would constitute control and therefore would be in violation of SEBI's takeover norms. And that's something important that FRL has pushed across before the Delhi High Court. Argument number seven is that Amazon has falsely claimed that it gained knowledge of this issue only as late as October of 2020, whereas WhatsApp chats before the Delhi High Court have shown that information was shared with Amazon by Future as well as Reliance as way back as May and June of 2020. That's argument number seven. Number eight is that Amazon is only trying to blow smoke in the face of the regulators, that Amazon is misleading the regulators, trying to essentially delay the approvals that are important required for the 24,700 crore rupee deal. And the final argument is that Amazon essentially is acting like a dog in the manger. Those were the exact word used by the council, that it's causing mischief, and that the approach is that if they can't get their hands on FRL assets, they'll ensure that the SIP sinks. That's essentially a broad takeaway of the arguments that have been made by the FRL before the Delhi High Court. Joining us now to decode this issue, which is currently at play, are legal experts. Joining us, Mohit Paul, advocate with Supreme Court, Manoj Kumar, he's a founder and managing partner with Hammurabi and Solomon Partners, and finally Sachit Jolly, he's a partner with DMD Advocates. Gentlemen, a very good evening. Appreciate you joining us, taking time out for us. The first question, Mr. Kumar, I'll put this to you, and this is with respect to FRL's participation in the emergency arbitrator proceedings. The first question that I'm going to ask you is that does mere participation in these arbitral proceedings subject a party to accepting, to being bound by the orders that are passed by the arbitrator? Mr. Kumar.
Not at all. In fact, there are multiple reasons for that. One is that FRL has participated under protest and without prejudice. Secondly, that the Indian law to which the entire arbitration is subject to does not give an open-ended hand to an arbitration tribunal to join third parties as parties to proceedings. There have to be very strict norms to be followed. And in fact, the Act only empowers the courts to do it, and only as an exception in case arbitration rules provide of institutions, then also very strict norms have to be followed. Thirdly, the emergency arbitrator does not even qualify as arbitration tribunal under Part 1 of the Indian Act. So therefore, firstly, they are not a tribunal themselves. Secondly, they are barred under the Indian law from adding third parties to the proceedings. And fourthly, that in any event, any kind of an interim measure, including bringing FRL as a party and passing the orders that they have, is reserved for the courts in India under Section 9. So they're completely without jurisdiction. The arbitration tribunal does not exist in the eyes of Indian law, and therefore, consequentially, the award itself is not capable of enforcement, and therefore cannot be challenged as well, because does not exist in the eyes of the Indian law.
Fair enough. Mr. Kumar, you've made interesting points, and that is with respect to the status that an emergency arbitrator enjoys, if at all, before the Indian law, before the Arbitration and Conciliation Act. We'll come to that. That is, in fact, the second key point that we would seek to dwell on. But staying with this one issue, Mr. Paul, if I may come to you, the question that again arises, and this is the argument that Future is putting across, FRL has put across, is that, look, we did participate, but we're no in shape or form bound by it because we did so participate under protest and without prejudice to our opposition to the jurisdiction of the Singapore Tribunal. What do you make of that argument, Mr. Paul?
Well, that's actually correct view which they've taken, because of the simple reason that they participated under protest. If there is an order which is passed by the emergency arbitrator, why is it that Amazon is shying away and not enforcing it? Where will they go for enforcing that order? They very well know that that order is not going to be applicable in India. Like Mr. Kumar also said, it's Section 9 of the Arbitration Act which governs the law in the country. Obviously, Amazon was aware of this, and that's the reason why they did not approach the Indian courts. They knew they'll be hit by this, and that's the reason why they went for the route of the emergency arbitrator. But it's as good as a paper order, actually, nothing else.
Fair enough. Mr. Jolly, if I may get you in on this conversation as well. Again, the same issue here. The issue that is arising is that, look, once a party has participated, it will necessarily have to accept the orders that are passed by the arbitrator. That's the question. And that is, in a sense, with respect to an arbitral tribunal. This is not exactly an arbitral tribunal that we're referring to. This is an emergency arbitrator. So does mere participation subject FRL to being bound by the interim orders that have been passed, Mr. Jolly?
Well, not according to me. I think both Mr. Paul and Mr. Kumar have rightly pointed out that mere participation in itself does not bind FRL to the orders of the Singapore, the emergency arbitrator. But more importantly, I think Mr. Kumar briefly touched upon it. I think that's a more pertinent point here, which is that can you join a non-party to an arbitration without its consent and without a court order? And that, in fact, in very limited circumstances, can a non-party be joined to an arbitration? I think that's the key crux being argued in the Delhi High Court as of now also, that even if there is an emergency arbitrator, because, one of the points which Amazon has argued is that both the Delhi Arbitration Center and the Mumbai Arbitration Centers have emergency arbitration clauses. But can you have an emergency arbitral award or an injunction against a party which is, Reliance or FRL, which are not even party to the main contract which is being enforced by Amazon? I think that will be one of the key critical questions which the Delhi High Court will answer.
And
it's interesting, Mr. Jolly, that you raised that point, and I'll come back to that with the... Yes, Mr. Kumar, you were saying.
Yeah, I just wanted to add one more issue with respect to the non-joinder of parties. In fact, the question of jurisdiction that FRL has challenged the jurisdiction of the interim arbitrator is something that the tribunal, as and when it is constituted, is going to take it up. So while the jurisdiction issue is still pending to be decided at a future point in time, you have an interim order by a tribunal which is not recognized by law, and you want to enforce that. There's a big lacuna right there. And that lacuna is visible and accepted by Amazon itself by the fact that instead of going ahead and enforcing that award or trying to enforce that award, they only try to use it as a bullying tactics to approach regulators. So we'll develop it as we come, as and when new questions come. But that's the inherent part, that the jurisdiction itself has been challenged and yet to be decided at a future point in time.
Sure. So the question of jurisdiction is yet to be decided by the arbitral tribunal, which is yet to be constituted. So a number of question marks there. But on the very issue of can a party be joined to these proceedings, now Amazon's response has been throughout that, look, this question, this objection was raised before the emergency arbitrator, and that the emergency arbitrator has held that it is fair and it is reasonable to go ahead and to attach FRL to these proceedings. That is Amazon's submissions before the Delhi High Court in summary. Mr. Kumar, what do you make of that? Is there any grounds there with respect to perhaps attaching a party, because once the emergency arbitrator has held that, at least for the interim, is a final, perhaps an order that needs to be complied with?
Absolutely not. In fact, it's completely without a basis for two reasons. One is, as I mentioned, that the very jurisdiction of the emergency arbitrator, which has been challenged under protest when FRL joined the proceedings, that issue itself is to be taken up by the tribunal at a later point in time, or even the jurisdiction of the tribunal itself. And secondly, that the order itself, the award passed, is not appealable. These kind of inconsistencies and lacunas make it an award which is not recognizable under Indian law. Today, if FRL or any party aggrieved by that award does not have a forum to go and challenge it. So it's not an award which is enforceable here.
It's interesting that you point out the lacuna about the lack of an appeal, and that being an important lacuna. Mr. Jolly, if I may come to you, and here we progress to the second key issue, that the Indian law simply does not recognize the concept of an emergency arbitrator. It's absent from Section 34. It is absent from Section 9. There is no creature called the emergency arbitrator in the Indian arbitration law. So, Mr. Jolly, when I come to you, what does that do to the enforceability of such an order, given the lacuna involved, that there is simply no creature recognized as an emergency arbitrator? Does that perhaps come in the way of enforceability? Mr. Jolly.
Yes, I think that's what FRL has argued. I won't stretch it to a level to say that emergency arbitral awards can never be enforced. In India, in fact, there have been instances in the past where they have been enforced. I won't pitch it to a very high level of saying it's completely barred, but in the peculiar facts of this case where the emergency award, so-called emergency award, first of all precedes the question of jurisdiction which has been raised, and secondly is against a party which was not the original parties to the contract and to the arbitration contract, is kind of a extension which in my view suffers from grave legal defects.
Mr. Kumar, if I may take you in on this subject, on the emergency arbitrator, this creature being absent from the Indian law, what I wanted to draw your attention towards an argument that was made before the Delhi High Court is that the Law Commission also had made a recommendation for perhaps adding the emergency arbitrator to the Indian law. That did not happen. The Parliament, in its wisdom, did not act on it, did not include that amendment to Section 2. Just your reading of the situation, that even after a Law Commission recommendation, the Parliament has not acted on it. So is that a very conscious decision to not allow the concept of an emergency arbitrator, Mr. Kumar?
Yes. So when we talk about this, when we discuss this issue in the context of a certain set of facts that we have today, we need to see the law that is, not the law that ought to be. In the view of the Law Commission, 246th report, as well as the report of the special committee constituted under the chair of Justice B.N. Sri Krishna a couple of years ago, both have recommended that to bring parity on emergency arbitration and therefore to introduce and bring it within the ambit of Part 1. That is as it is, as far as the recommendations go. As far as the law that is concerned, I think the Parliament, as also the courts and the way the Act exists, very clearly provide that interim measures are measures which have to be very considered, and prior to constitution of the tribunal, if such measures are required, then the courts have jurisdiction. Section 9 is provided, and it's very clear. It has passed all the judicial tests of validity. Therefore, there is absolutely no ambiguity that Indian law does not recognize, as of today, the powers of a temporary tribunal constituted only as a pre-tribunal stage, at a pre-arbitration stage, to pass interim orders. That's one. Secondly, I would want to just join issues with
Sure.
Sachin, just to clarify something in addition to what he said. We've had two judgments of 2016 and 2019, which are seen as contradictory by a lot of legal minds, and one of it says that the court recognized emergency arbitration. We need to be very, very clear that the court did not recognize emergency arbitration. The court interpreted in those particular facts that a certain arbitration award passed by a tribunal which fitted and fulfilled the trappings of the Indian Arbitration Act and therefore allowed it to be enforced. There's no clear categorical clarification to enlarge the scope of arbitration tribunal in part 1 of the Arbitration Act, and therefore the discretion still lies before the court, and the discretion is part of inherent powers read with the Arbitration Act and the rules under High Court rules and the Constitution. We know all those inherent powers, where all they come from. And those inherent powers always exist. But the fact of the matter is the Indian the Indian judgments do not enlarge the scope of Part 1 of the Act. And that is where we are. And therefore, especially in the peculiar circumstances that Sachin rightly mentioned, that the issues of non-joinder, joinder of non-parties who are not a party to the arbitration agreement. In these circumstances, more so, there's absolutely no question that such an award is enforceable in India.
Right, Mr. Kumar. Mr. Paul, we're supposed to head into a break in just a few seconds. A quick word to you. I was about to, in fact, raise this issue. Mr. Kumar preempted that question about the judicial precedents. There are a few cases, few and far between, in fact, a couple to be specific, which allowed for such orders, interim orders, to be participated. But as Mr. Kumar has clarified, that was done under a very limited set of circumstances, under very specific situations. So how does one look at legal precedents when looking at these emergency interim orders? Mr. Paul.
Well, all said and done, each case is distinguishable, right? And as a matter of fact, in this case, I don't think that really warranted that the emergency arbitrator and the award which came to be passed by the emergency arbitrator was really called for. Sachin has already rightly said that joining non-parties to a particular proceeding does not bind them with it. So, and if Amazon is so aggrieved by it, then why is it that it just shied away and not enforced that award till date?
Sure. Interesting thoughts. We'll come back to that in just a bit. Let's head into a very short break. We'll continue this conversation and decoding this battle between BEZOS versus BIYANI. We'll continue this conversation on the other side. Keep watching. Well, a very good evening once again, and welcome back to a special broadcast, BEZOS versus BIYANI. Let's continue from where we left off. Mr. Paul had said that if this order was in fact an actionable order, why has Amazon not resorted to filing enforcement proceedings? Why is this order not being enforced? Taking cue from that, let's proceed with Mr. Jolly, if I may come to you on this one issue. The concern that FRL has raised is that while not enforcing the order, but by writing letters to various regulators seeking regulatory action in terms of delayed approvals, what essentially FRL has alleged is that this is a mischief being caused by Amazon. Just your assessment of these proceedings, that with Amazon not looking to enforce these orders, but rather writing these letters, that does, in a manner of speaking, play into the narrative of FRL before the Delhi High Court that this is mischief being caused. Mr. Jolly.
Absolutely, no doubt. I think you're absolutely right. And I think the argument seems to make sense that you can't, since Amazon is unable to enforce this award in India, you write to regulators, create confusion, delay the proceedings, delay the approvals, and then kind of cash in on the confusion which prevails. That seems to be a strategy. I mean, I'm not privy to it. I can't really comment it. But you're right that the FRL's argument on that ground seems to hold water. I think another reason why probably, and I'm just guessing, Amazon is not enforcing or not seeking to enforce the award is the fact that if they seek and enforce the award, which award will say that all the agreements, the top level SHA concerning FCPL and the subsidiary SHA with FRL are an integrated document and have to be read together. That will in itself constitute probably a violation of the FEMA regulations and the FDI norms, as well as could flout the SEBI regulations as well. So I think probably it's a conscious decision, and that's why this writing letters is being, the tactic has been used.
Fair enough. An interesting point there being raised, Mr. Kumar, if I may get you in on this point that has been raised by Mr. Sachet Jolly, that as far as, and this is in fact one of the arguments that was raised by FRL as well, that there appears to be a U-turn of sorts by Amazon. Before the CCI, at the time of making the investment, they said that, look, it's only limited to FCPL, future coupons, it's got nothing to do with FRL. Now in their latest letter to SEBI, they say that this was a single integrated transaction, which involved both FCPL as well as FRL. The question that comes to light is that, does this perhaps constitute control? And if it does that then perhaps stand to be in violation of SEBI's takeover norms, FEMA regulations? A number of questions being brought to light by Mr. Jolly. Your thoughts on that, Mr. Kumar?
Yes, so let me first come to the issue that you placed to Sachet to answer. With respect to the mischief they're trying to create. Now, Amazon has been trying to, it has always had the whole sequence of events since its presence in India is showing, is to continuously look the other way from the law of the land. So let's see what is happening. There's a proceedings to be initiated under Section 230 of the Companies Act for a set of restructuring, for consolidation and hiving off, which is the scheme for which approvals have been sought by all these companies from the stock exchanges. The Companies Act has a certain provision. If somebody is aggrieved, especially as a shareholder, to the process, they have a say, they have a right to object in the course of the proceedings as and when the court issues notice to them, or the court seeks to take approval of the shareholders as per the provisions of the Companies Act. But that is not what Amazon seeks to do. The Amazon tries to straight away block the process much ahead of the process before it comes to the NCLT, knowing very well that they don't have the grounds and capabilities to stall because they're not entitled to under the Indian law. Second, with respect to their positions of control, when they went to the emergency arbitrator, they tell the emergency arbitrator that they have special rights, protective rights, and material rights, right through flowing to FRL, through FCL. When they come to the Indian regulators, they say we only have protective rights. So they have been in the devil and deep sea, speaking different languages, half-truths, all across, whether it was before the Competition Commission of India, when they had to take the passage for their investment, or before different regulators who have been examining their entire working structure in India with Cloudtail and other structures they put up. So they have missed the bus on control, and now they actually stepped on a legal minefield, by exposing themselves to a level where there are definitions of control under SEBI regulations, there are definitions of control under FDI regulations. Both of them have been violated by them. So I think they are very clearly.
So a legal landmine.
They have already violated the control norm by exposing that, enforcing the right to control.
So Amazon has stepped on a legal landmine. That's the view that Mr. Kumar is giving us. We're running out of time, Mr. Paul. A final comment from you coming in that this is essentially a case of Amazon with an investment of 1430 crores seeking to block a deal which is 24,700 crore rupees. The math is not adding up other than the legalities. Just your reading of the situation. How do you think Delhi High Court will look on it when it takes up this case tomorrow?
Well, unfortunately, I really can't comment on how the High Court is going to look into it. It's very simple. You see, you don't have 27, you may have 27,000 crores, but if you can actually save that amount of money and put in only 1,400 odd crores and manage to hive off an entire deal. Look at it from that aspect. And it is very hard to imagine that Amazon wasn't aware that they will get some sort of an equity and a stakeholding and a shareholding in future. It is absolutely really unthinkable, to be very honest. They are advised by some of the best legal brains in the country and the world. It can't be that they weren't aware that they will get a stake in FRL, which is something which is not allowed under the Indian laws. That is really, really, really unthinkable. And
you're saying they should have anticipated it.
Yes.
So Mr. Paul is telling us that Amazon should have anticipated this legal trouble. A quick 30-second comment coming from you, Mr. Jolly, and this will be a High Court observation that, in fact, was made over a course of the proceedings. The High Court had observed that if they were to allow the ad interim relief that FRL has sought, which is to restrain Amazon from writing to regulators, that necessarily will mean that they'll have to declare that this interim order by the emergency arbitrator is nothing but a piece of paper. Do you agree with that observation that fell from the High Court, that is what is required to restrain Amazon from writing to the regulators?
Well, it could be the other way. Could also be that the High Court, instead of deciding whether it's a paper order or it's an enforceable order, could also say that, look, you must also desist from making these unfounded allegations without the constitution of a proper tribunal, without first the issue of jurisdiction being decided. Till that is done, please also refrain yourself from making these unfounded allegations, because these have to be then decided before you write to regulators and the regulators decide upon that. So, either ways, you're right. The High Court will have to, in either of the case, decide they will have to restrain Amazon either way, whether by declaring the order as a paper order or otherwise also, without even getting into that question.
Right, Mr. Jolly, thank you so much for joining us. Mr. Kumar as well, and Mr. Paul, thanks for joining us and sharing your thoughts with us, sharing your perspective with us for the benefit of our viewers. Let's keep in mind that tomorrow is when the Delhi High Court takes up this case for further consideration, and hopefully will give more clarity for all the stakeholders involved. Thank you so much for joining us.